All right, now we are joined by Judge Jim Verellen, who's running for re-election to the Washington State Court of Appeals, Division 1, District 1, Position 3. So go ahead with your 2-minute introduction.
Thank you so much for giving me the opportunity to be here this evening. I would have made it to the membership meeting the other night, but it was my 37th wedding anniversary, and I had to choose use a little discretion, and, so you lost out. I'm delighted to be here. I'm a judge at Division 1 in downtown Seattle. I was appointed by Governor Gregoire last November when Judge Ann Ellington decided to retire. Before that, I was a mediator and arbitrator for about 2 years in Seattle. Before that, I was a commissioner at the Court of Appeals for about 19 years. Before that, I was an associate and then a partner in a law firm that's currently known as Vandenberg Johnson Gandera. So I'm unopposed, which kind of takes the pressure off, maybe all of us, but I'm delighted to be here, and I think it's important for judges to be visible in the public, and that's why I wanted to come this evening and have a chance to chat with you. I think the Court of Appeals is an especially important court. I think it makes decisions that influence the development of law, and you decide the cases that are not just before you, but you're making decisions that are going to influence and guide judges, trial judges, and attorneys, and the public in a variety of areas. It's very challenging. It's also very satisfying. I think I have strong support in the Bar Association. I've received exceptionally well qualified ratings from all the minority bar groups, and I think the appellate bar is strongly in support of my appointment, and that's one reason perhaps I don't have an opponent. So I'm delighted to answer any questions that you have, and I'm very much again for having me.
Great, thank you. So now we have our 5 prepared questions, 2-minute answers to each of these. And we'll just go around the room and generally start with number 1, or should we?
In what areas of law have you practiced in your career, and which are you most familiar with? And does that experience make you qualified to sit on the Court of Appeals?
There's no exception for experience. In private practice for 14 years, I was in a civil law firm. I did a wide variety. Our firm had 6 practice groups. I was in 5 of the 6 practice groups. I did litigation, business, commercial, some personal injury, some defense, insurance defense type work. I did a few dissolutions, a little bit of domestic relations work, a fair amount of real estate work. In addition to litigation, I also had an office practice, so I did some real estate lease work with large commercial tenants, new business formations. So a pretty wide variety of civil litigation. I didn't do any criminal work, but since during the 19 years I was a commissioner at the Court of Appeals, I had tons of criminal cases that came before me. And so I think I have a balance, and I have a broad, diverse background in the law.
Great. John, number 2.
Okay. What barriers to access are there at the Court of Appeals for unrepresented litigants, people with disabilities, and other vulnerable populations? And what steps have you taken to promote access to justice?
Well, that's a very challenging question, a very challenging area. The number 1 barrier to access in the entire judicial system, not just the Court of Appeals, is the cost. I mean, what's the point of having the most efficient, effective, sophisticated legal system in the world if only 1% of the population can afford to avail themselves of the courts? So that's always the underlying tension. But you have to balance maintaining the quality of the court's performance, having a set of rules that apply equally to everybody, and trying to find a way to help pro se litigants, self-represented litigants, who are increasingly involved in litigation, especially in the trial court. I think last I heard anecdotally was in domestic relations, it's well over 50% of the litigants are self-represented. And there's some carryover to the Court of Appeals. So that's always a concern. In terms of barriers, physical barriers, accommodating individuals with limitations, the courts work pretty hard to try to deal with that, in terms of just physically getting in and out of the court, to having special infrared listening devices for hearing impaired individuals, There are limitations, though. You can't just redo the entire courtroom. You might want it to be, but you hope to look for opportunities along those lines. So overall, I don't think there's any magic wand. I think the low-hanging fruit's on impact in that arena. It doesn't mean it doesn't warrant careful ongoing consideration, and I think that's important to everybody.
Clayton, number 3.
What state or federal Supreme Court decisions do you disagree with?
That's a question that Governor Locke, when I interviewed with him a long time ago for a spot, and Governor Gregoire on another occasion asked me the same type of question. And I think I'm most concerned with our state Supreme Court when it issues splintered decisions. And that happens more often than I think anyone would hope, where you end up with in the last month on the Batson standard for when you can use peremptory challenges to exclude minorities from the jury panel. And the United States Supreme Court has adopted this standard. And it's a difficult standard because it ultimately turns out whether there's been purposeful discrimination. And that's a very difficult thing to demonstrate. So the opinion came out, and this is 3 weeks ago, and there's a lead opinion that's got, I think, got three people who signed off on. There's 2 concurring opinions, 1 dissenting opinion, and all of the arguments, positions are helpful in the sense of a public dialogue, but they end up criticizing Batson's challenge, but declining to adopt any new standard because of the lack of complete briefing in this case, and contemplating maybe a potential rule that would change the standard. Well, that's helpful in a sense, but you kind of sometimes, when you get that much splintered decision-making at the Supreme Court, I think you end up with not having much in the way of guidance. Sometimes it just adds to confusion, and I think that's a difficult thing. It's easy to criticize from the sidelines, but I think those are the kinds of decisions that I wish had come out a little differently, a little more focused.
Jack, number 4.
This is 2 parts. Do you support the current system of electing judges, or do you support some other system, such as appointment or an appointment and retention election hybrid? And if elections continue, what reform of the current campaign finance rules would you support?
For about the past 8 years, I've taught classes at a couple of high schools in Seattle on how judges are selected in Washington State, because it's just a topic that once an AP history class at Garfield, senior government classes at Garfield, and some government classes at Bishop Blanchett. And there's never time in the curriculum for them to get to that topic, and so I made connections with a couple of teachers, and so every year I make a presentation, and Judge Cox participates in some of those. And the whole point of it is, how are judges being selected? How does the election system work? You, senior high school student, who are about to go vote for your first election, how are you going to find out about judges? What qualities do you want? What interests? How are you going to find the information that will help inform your vote on those topics? And the discussion inevitably comes to exactly this point. Is the election better? Should we have appointments? What are the advantages? What are the disadvantages? The retention system, the Missouri system, those other systems. And in the short time we have now, I would just say every system has its own disadvantages. Every system has its own advantages. I think we have an election system in this populous state. I wonder if we would ever shift away from that, and I think we're likely or not to. So in a way, I think it's kind of a good discussion, not to be a wet blanket. But I think we have an election system. I think it has some advantages. If the voters are able to get information about the candidates, and that's the huge restriction. And there's a great website in WashingtonVotingForJudges.org. And so that's one of the main points, is to get the high school students familiar with that website. So they'll hopefully go look at it, or they can gather one quick, easy place, newspaper articles, information on contributions, and maybe campaigns, and that kind of information.
Elizabeth, number 5.
Please tell us about the types of community service you do and the professional and public organizations you've been involved in.
Well, as you are aware, there are some limitations on what judicial officers can do in that regard. I've been a court commissioner for 19 years. I've been involved in a variety as I have 3 adult children and 2 grandchildren, so I've been involved in a lot of those kinds of organizations, on the board of directors of a ballet company and on the board for a baseball organization, youth baseball organization, involving rowing programs and coach basketball and soccer. Beyond that, I've been involved with, I mentioned a minute ago, the high school education program, which I think is it's important to me. And I've been involved in bar association committees and activities and judicial committees. There's education committees that organize education programs for judges, and I've been on several of those committees. So I'm not sure I have much more detail. It would be very meaningful. But that's kind of a quick overview.
Great. Now we'll go to follow-up questions. Is there 1 minute answers? So Clayton and then Barry.
I wonder if you could talk to us for a minute or 2 about the Citizens United decision and how you see its effects ramifying through the courts and international life.
Well, I guess you asked me about financial things. I didn't quite get to that point, but I think it's the impact of having unfettered financial contributions from any group, corporations, which are deemed persons under that decision, and with a free speech right to do contributions, really opens the door to great mischief. And I don't think there's an easy answer. Every time you look at other campaign finance limitations, every time you squeeze down on one abuse, you just have clever people who find another way to evade or work around those kinds of limitations. And I think that's going to be true in judicial campaigns. I think it's an interesting concept to consider public financing of judicial campaigns where the candidates would opt in the given amount of funds. Governor Raymore proposed that kind of system a couple sessions ago. The dilemma is, where's the money going to come from for that? So again, I don't think there's a magic wand, an easy answer. I think it's a great concern.
Okay. David.
First of all, just a statement, which is thanks for coming, you're unopposed, and I think it makes a value statement that you chose to spend time with us here this evening. But there's significant fallout when you look at election results consistently when people get down ballot to the judges. Then you mentioned the website. So I have actually a 2-part question. One is in part a follow-up to Clayton's question, but more general, which is what kind of finance reforms, are there any specific finance reforms that you do support involved with election of judges and information, getting information about judges to voters, right? The vehicle, right? The second part of my question, if the first one wasn't confusing enough, is the second part of my question is what do court commissioners do?
The second part first. It's a great question. I always tell my friends that commissioners are half judge and half janitor, and they do A to Z, keeping the cases moving through the court. Commissioners at Division I decide appeals on the merits, termination of dependency cases, other motions on the merits when we used to have those. We don't currently. So important decisions. Discretionary review. Not every case is entitled to an appeal. If you are entitled to, you can ask for the option for an appeal. And so those can be important decisions. Emergency motions of all kinds, attorney fee rulings, a broad variety of questions. The first half of your question, I think the answer has to be, how do you get more information to the voters? Has to be technology based. And I struggle with Facebook. I know there's all kinds of goofy things on there, and malicious things, but the reality is, how do most people get their information? And I think if you're going to wait for people to go to the library, public library, and do some research, I think that's tough.
Additional question? Yeah, Jane?
So I'm going to follow up on that in your answer to also the issue about vulnerable populations. You said that technology is the answer, and yet we have a strong digital divide in our communities, and we also have issues of language access. And when you were speaking to the issues of vulnerable populations, you didn't mention those issues. So I'm curious about your response to how do you make sure that people who may not have digital access or may have language barriers or other forms of access barriers that you haven't yet addressed? How do you make sure they have access to learning enough about the judicial system, the process, and to some degree their own rights therein?
That's, I think, a very complicated question, and I think a very important question. And I think you're right. What does it do to have this deluxe website? There's a huge chunk of the population who can't even access the internet, let alone have access to a computer. And a small help is, I think, the public library system in Seattle because it started trying to get access to people that way. The voters pamphlet does have, is another opportunity to give information to people, especially in multiple languages. I think that's part of the answer. I don't think it's satisfactory. I'm not sure how you get to the point where you're going to have enough public funds available. I think we could come up with a lot of great ideas, but I don't know how you fund it to be realistic. And it doesn't mean it isn't important. We don't keep working at it, but I think it's always going to be a tough issue.
Evan?
So first of all, thank you again for being here. And I'm glad that you went through your full resume. My mom's actually a current partner at Vanderbilt Johnson & Gary.
Oh, really?
So that's kind of cool. So my question, I used to work at the legislature, and when I was down there, we used to hear a lot of conversation about funding for the courts. And I wonder if you could speak a little bit. I mean, especially as a commissioner, you've been in the court system for a very long time. And probably have I'm interested in your perspective on the way that funding has shifted over time, the challenges that has posed for the courts, and the way that you help mitigate those challenges.
A very timely question. The last 3 legislative sessions have been, maybe 4, I guess, to be accurate, have been, borderline devastating to the judicial branch. As an illustration, in Division 1, when I was a commissioner, when I came, I was the 4th commissioner, and over time, some of the people we had 4 commissioners. Then in the course of, I think, 4 years, we went from 4 to 3 to 2, and when I left, there was only 1 commissioner left. 3 weeks ago, we finally got enough money in the last budget to hire back a 2nd commissioner. And I know from the outside looking in, it's like, well, what do they even do, and how does it impact things? It has an impact, and it's been overwhelming. And the judges are taking on more of the commissioner's work. Everybody's trying to make it work the best they can, but it is a devastating problem. And I think when you're stuck with the revenue coming out of the general fund, I'm not sure, and you get sweeping cuts that are across the board. Other agencies have more. We have people and rent, and that's our budget. So it's
Can I a follow-up?
Very
Quick follow-up. Just to tie back to our earlier conversation, could you speak to, in particular, how the lack of funds or how those budget cuts maybe disproportionately or proportionally impacts vulnerable populations?
Well, I think that's a sophisticated question. It's hard to pinpoint. I think overall the court slows down. That's the reality. The wait time to get an appeal or oral argument had been down to 3 or 4 months after the briefing is completed. It has stretched back out now to double, triple that. Hopefully we're trying to keep a lid on it, but it's just something's got to give. And that also takes away the time you have to work on special projects and new programs. And I think it's again, I don't want to sit here and say I have a magic wand and I can solve that problem, but I think it's an important problem.
Thank you.
So I have a question. So Turns out that the last, you mentioned that you replaced Ann Ellington after she retired. Turns out that the last Court of Appeals judge that we interviewed 4 years ago was Ann Ellington. And as you may recall, she was actually contested and won in the primary. But because, and I think Clayton was there and Toby may have been there, maybe everyone else may be new since then. But maybe Elizabeth, if you're here. I'm just curious, just because we sat down with her, how would you kind of compare and contrast like her style or her approach as a judicial officer and your approach, and what's your view on her career?
Well, I'm delighted that she's been a very strong supporter of me getting the appointment and getting ready for an election cycle. I only aspire to try to reach the level of accomplishment that she has. She's an exquisite writer. We've read her opinions. She can make the most complicated things very digestible. She has a knack for getting right to the heart of an issue, both at oral argument and in her written materials. And she has a very, things at the surface which seem straightforward, she's able to pierce through that and look for the more sophisticated nuances of what's really going on in the case. And I think that's a great skill to have. And so, I bang my head against the desk and I try to do the best I can, and I hope I get close.
Great. So we're about out of time. If you want to take just 30 seconds for a closing statement.
Well, I think there is a problem in our community and in every community in terms of elected judges, and that's getting information to the voters and voters having good information to make decisions on. Again, I don't think there's an easy answer to that, but I think one point is to try to do a better job for both ends of that. And I think judges have to work harder getting out into the community, having a chance to talk with people, and some people have some clue. Most people have no idea. Most attorneys don't know who's at the Court of Appeals, let alone citizens and what they stand for, what they're involved with. So I think that's an important thing I hope to work on.
Great. Thank you very much.
Thank you.